Really, the purpose of this panel is to discuss what I think is the hardest part of my job, which is striking the balance between good parents and even parents who are struggling but still care about their children and are trying, and parents who are failing their children and whose children need to be taken out of the home. It's a very, very delicate balance. It's a very emotional subject. And it's a hard balance to strike. And so I'm not going to stand up here and say that this is an easy question. This is the most difficult question that I deal with. There's certainly a liberty interest involved, but more importantly than that, we have if you went to our panel yesterday, you saw that we have a failing, has a recently really badly failing foster care system. So we have been taking children from bad situations and putting them in worse situations. And so before we get started, there are a couple of housekeeping matters. One is that this panel qualifies for CLE hours, continuing legal education. You can sign up for those hours at the back of the room. The other thing is this week we're highlighting the Texas Prosperity Promise. It's a pledge to secure and extend Texas's success through 2019 and beyond. It's more than a plan for the next legislative session. It's a commitment to the guiding values that are critical to keeping Texas prosperous and free. You can read about the Texas Prosperity Promise at texasprosperitypromise.com and sign it there. You can also sign it on your app. If you have the app, there's a specific button for that. Related to the Texas Prosperity Promise, and one of the commitments and the principles in the Texas Prosperity Promise is self-governance. So the mission of my center, the Center for Families and Children, which is the newest policy center at TPPF, is we exist to increase self-governance within families and communities in order to support human flourishing within a civil society. Thank you. We at TPPF and the Center for Families and Children, we envision a Texas where families are intact, where parents rise to the level of their responsibilities to each other and to their children, where children are free from harm by their caregivers, where families are connected with each other and with social institutions and their communities of trust and support. So the dialogue here is something I've written about and something I've spoken about, and we had some success in the legislative session on really defining the rough edges of where the government might be engaged in some overreach and keeping kids with parents where that is the best option for them. And just this week, as I've looked around as I've noticed things that are coming out of the news, just in the last couple of weeks in the Ninth Circuit Court of Appeals, that court sent a case back to the lower court and said that the parents can sue CPS workers where the CPS workers removed a child for the parents taking pictures of the naked bottoms of their toddlers. So CPS had removed kids because they took some cute baby bottom pictures and placed those kids in foster care, and the court said, that's ridiculous, you can sue those people. The Arizona Supreme Court found a completely groundless removal recently and said the only reason they can see that these children were removed from their parents is because they're highly adoptable. In Utah, we recently had, actually yesterday, a bill was passed that protects parents from having CPS investigate or from criminal charges being pressed for them allowing their children to play outside unsupervised, from them allowing them to ride their bicycle back and forth to school, from them allowing their children to stay at home for a reasonable length of time without supervision, and to allow them to remain in their car for just a moment while their parents go to pick up their dry cleaning that's right there in front of them. Again, these are very emotionally charged topics, right? Because when we think about leaving children in the car, we think about the children that die. The horrible cases. And the question is, do we overreact whenever we do that? And we say, you can't even leave your children. I'm going to tell you a personal story, and there's probably CPS workers in here, and if I get a report, I have lawyers on retainer for this. I have 5 kids. They're all young. They're all in car seats. We have this vehicle that we purchased specifically and spent too much money on because it had side curtain airbags, and from what I know, airbags are just going to pop out from everywhere if we ever end up in an accident. I do mobile order at Starbucks, and I'm a bit of a Starbucks junkie. So mobile order, you punch in your order, and they have it ready for you, right? Same way with dry cleaning. Here's my dry cleaning. I park in front of Jack Brown. I run in. I leave my kids in the car. It's currently a misdemeanor in Texas. Every time I do that, I'm committing a misdemeanor. And here's why. Because in my expert parental judgment, and I am the expert parent for these children, it is safer for me to leave those children in that car, in the $300 car seats that are designed to protect them, and the $60,000 car that's designed to protect them, than it is to go hold hands and run like heck through this parking lot. We're all going to pray that you don't get run over, because statistically, the most dangerous place for children is a parking lot. So there are, and I'm not going to sit here and say we're talking about hundreds and hundreds and hundreds of thousands of kids. There are a significant number of people, and if these are your kids, these are the most important kids, right? We all fear CPS coming to our door. Just yesterday in the Austin American-Statesman, there was a story about a mom of an autistic child that took her child to Lady Bird Lake. This was a miraculous thing in their life because the child has problems with sensory issues, and going out and getting him out is a real problem. His hair was matted and tangled because he has sensory issues and won't let them comb his hair. His clothes looked a little bit disheveled because, again, the things they can do with him are sort of limited. They had the best day they'd had in a long time at Lady Bird Lake. They played for a long time. As they were going to their car, they were approached by the authorities because someone had called the authorities because they were concerned about the way the child looked and whether he was being mistreated. So this is personal to me. I was raised by a single mom. She was a nurse. She worked 7 a.m. to 7 p.m. That was her shift. So from late middle school on, I was responsible for getting myself up, for getting myself on the bus, and for getting myself off the bus and back in my home. I knew where my mom was, and she knew where I was at all times. I knew that she was gone because she loved me, and she was working hard to provide for me. There is currently an effort going on to some people in Dallas that would make that a felony. It would make a felony to leave any child younger than 10 in a home unsupervised. So that's literally thousands of children in Texas that go right home on the bus and go into their empty home. What we ask for from parents is just too much. No one is honest about what they do in their homes. And I think if we're honest and we can just begin to reduce the culture of judgment around parenting, this should not happen at the expense of any child's safety. That is of primary importance. But at the same time, we need to open a dialogue around, does the government overstep its bounds at any point? I had a client, whenever I was still representing parents, I had a single dad who was raising a teenage girl. She was, I think, 14. They were having some arguments. I only have one little girl, she's 3, so I don't know if this is common or not around that age, but there were lots of turmoil in their household and lots of dramatic arguments. And at one point, she had a bottle of aspirin or a bottle of Tylenol, and she just threatened to kill herself by taking the whole bottle of Tylenol. And he said, "Go ahead." Now, he didn't think she would do it, right? And he was frustrated. But she did. She took that whole bottle of Tylenol right then. He swept her up, took her to the hospital, had her stomach pumped. CPS showed up, removed that child. Because they were worried about his parenting and whether or not that was an appropriate response. Because she continued to act like a teenage girl, she moved from a regular foster home into a residential treatment center because she was diagnosed with mental health issues and put on psychotropic medication. Before long, she was in a residential treatment center, not in the small town where she was from in West Texas, but in Houston. She ran away from that residential treatment center. One of her fellow inmates there helped her run away. And she met a nice lady who introduced her to a nice man at a hotel. And before you know it, that little girl was being sex trafficked in Houston. Houston police weren't really doing anything. CPS really wasn't doing anything. They were saying it's Houston Police's job. So that dad, the same dad that CPS says neglected this child or abused this child, got in the car and went down to Houston and spent days looking for her at all the crappy hotels in Houston until he found her and called CPS and told him that's where she was. So you can see that this, while it may not be prevalent, it's significant. I think it's a conversation worth having because the power of CPS is awesome. It's awesome and it's coercive. These are people that knock on your door and can come into your house, can ask things about your family, what your children know about sex, what body parts your children can describe. So this is significant, right? These people, my granddad always said that the most powerful person in Texas is the game warden. Well, that's not true. The most powerful person in Texas, I would say, is a CPS worker because it's the most intimate part of your life is your family and what goes on in your house. So let me introduce our panelists. I'll have to apologize in advance that we're all lawyers. So we're going to try to be brief. But I really think that lawyers are the gatekeepers. Lawyers in courts are the gatekeepers for people's rights and liberties, which I think that's this is our fundamental issue here. And so that's why I invited lawyers. You know, due process works for everybody. It works for the guilty and the innocent. It separates the wheat from the chaff. And so if everyone has good due process, I'm confident that we can separate parents who are good in care and need resources from parents that are abusive and neglectful and are irredeemable. So to my immediate left is Judge John Schmude. He's the presiding judge of the 247th Family District Court of Harris County. He's been in that position since 2014. Prior to the election to the bench, he was a family law and business attorney and president of the Schmude Law Firm. He served as vice president of a Houston-based bank and credit union consulting firm and a high school teacher of history and science. D. Hobbs is next to him. He's elected as the Williamson County Attorney in 2013 and re-elected in 2017. Let me silence my phone. I was supposed to tell you to silence your phone, so we'll just do that together. How about we? So prior to election, he was a member of the Williamson County Attorney's staff and served in various capacities, including criminal court prosecutor, family justice attorney, criminal courts chief, until becoming elected county attorney. He's received recognition from the Texas Municipal Police Association for his work with DWI prosecution. He's been recognized by the Children's Advocacy Center as a Prosecutor of the Year and has received the Williamson County Crime Victim Advocate Award in 2 consecutive years for his service on behalf of victims of crimes. Next to him is, thank you. That's good. They all deserve it. And we're going to really give it to them at the end when we hear their brilliance. Chris Branson is next to him as a solo practice attorney who specializes in fighting CPS in the trenches, and he's won. He has a great record. He uses his experience to teach other attorneys at a yearly CLE sponsored by the Texas Homeschool Coalition. He also serves as Texas Homeschool Coalition's special counsel for CPS investigations. I, like Chris, was on the CPS SWAT team for Texas Homeschool Coalition. So when homeschoolers are getting investigated by CPS, they would dispatch us to make sure that homeschoolers understood their rights and that homeschooling is neither abuse nor neglect. So last on the end is Representative Dustin Burrows. Thank you. I interrupted your applause, Chris.
That's okay. That's okay.
Representative Burrows serves on the Agriculture and Livestock Committee and also on the Investments and Financial Services Committee. He's a member of the Texas House Republican Caucus Policy Committee, where he's tasked with making sound policy recommendations throughout the session to assist members on the House floor as they cast their votes. He began working at the law firm of McCluskey, Harriger, Brazil, and Graff immediately after graduating from Texas Tech Law School and Rawls College of Business with a JD and MBA in 2004. He's recently opened his own practice with his dad in Lubbock, and he knows that the private sector and not the public sector creates jobs and economic prosperity in the state, has continued to keeping taxes low and regulations low to allow for that. There you go. So I think we'll just start kind of broadly with what should the purpose of CPS's coercive awesome coercive authority should be, and then how do we define success in that? And I'd like to hear sort of everyone address why do we have a CPS, and what is its proper role? Yeah,
I'll
sure.
start. I would say the proper role of CPS and the use of that coercive authority is to protect children from abuse and neglect. Obviously, what we're talking about is we're balancing certain interests, and one of the things Brandon mentioned in his intro is that these cases are subject to strict scrutiny. And essentially what that means is, on one side, you have a fundamental constitutional right, the right to the custody, care, and control of your child, which is held by the parents, the right to direct the religious and moral upbringing of your children, the right to make educational decisions for your children, et cetera. These are all fundamental constitutional rights that are protected under the 14th Amendment to the United States Constitution. The state's compelling interest, obviously, is in protecting children, making sure kids are safe and free from environments where there's abuse or neglect. So an appropriate use of the state's coercive power is one such where the use of that authority or the need for the exercise of that authority is necessary in order to protect children from abuse and neglect. Okay, you have to be able to rebut the constitutional presumption, really, which is in favor of the parents. Okay, so there's a whole string of cases, both state Supreme Court cases and U.S. Supreme Court cases that discuss this. What is strict scrutiny? It's essentially where the state has to have a compelling interest. Okay, that compelling interest has to outweigh the individual constitutional interest and liberty of the parent, first of all, and second of all, the exercise of that authority has to be the least intrusive means in order to effectuate that state's compelling interest.
Yeah. That answer was so good, I'll probably just ask different questions as I go along. I mean, that was probably the textbook legal answer.
That's exactly what that was. It was the textbook legal answer.
And so I guess, yeah, Chris, go ahead.
Unfortunately, that's the textbook answer. It reminded me of a colleague of mine who was making a constitutional argument in another court, not yours, where the judge stopped him and said, sir, why are you talking about the Constitution? The standard here is best interest of the child. We don't do the Constitution here.
Wow.
And that was the judge, okay? Now, I'm sorry for reading. I know that makes for bad video, but I wanted to point this out in a book called Child Abuse, Family Rights, and the Child Protective System. Put the best summary of the problem here I think I've ever read. So the Child Protective System is a system that is, in its conception 40 years ago in the Mondale Act, had a utopian style of vision. It must be aimed at preventing all possible abuse or neglect. So legislators around the country put in place utterly vague laws so that no one could tell for sure all that fit into the categories of abuse and neglect. And the meetings could be infinitely expanded. The CPS would be given sweeping authority and discretion. This arrangement of things became the basis, in theory at least, for a universal monitoring of all American families. All utopias become dystopias, however. Thus, we have the nightmare of so many innocent parents accused and families intruded upon, frightened, separated, and their rights trampled upon. The CPS system is a touch of the totalitarian. And I see that every day. The laws, the concept of the laws are fairly benign. You know, protect a child from abuse or neglect. Who could be against that? However, the definitions of the laws, the idea behind the thinking of many of the caseworkers, many of the judges who definitely have their thumb on the scale for CPS in the court is that their standard basically is perfection for this child. And if you as a parent fall below perfection, well, we deserve to be in your business.
Well, and Mr. Hobbs, you sort of wield the awesome power of CPS indirectly as the elected county attorney for Williamson County. And so let us know sort of how you use that responsibility and how you, what metrics you use to know whether you're doing that well.
Well, and that is the problem. I don't think that either the gentleman sitting to my right or my left are wrong. I think that the least intrusive method and when should they get involved from our aspect is only when we must, not when we possibly could by statute. And that's the problem with 254 counties. You could take a cluster of 5 anywhere and see how the law is being applied, and you will find 5 different variations where you could.
And I'll easily acknowledge that. I practice all over Southeast Texas, and every county is different.
From that, it is scary, because from that, you can get case law, you can have parents being treated one way in this county and simply a mile away being treated differently, either protected or not. From our standpoint, we have 2 interests involved whenever a case is presented to us by the department, both that of the child and that of the parents. They are both our citizens, and I was talking with a representative on that's an important part of it, but if that's not an emphasis. You were asking what is success. For my office, success is reunification and never being involved in that family again. Everything after that is a failure of some sort. It doesn't mean that it doesn't happen, but you need to go into it with that mentality, and application is important. I appreciate that you train other defense attorneys. We find it hard to find passionate attorneys to represent the parents.
Yeah.
There's long hours, it's low pay, and it's very time consuming to do it correctly. I will show you a mentality in our office, and it goes through how you implement this. When I started as a line prosecutor in CPS over a decade ago, the thing was, it was just your time to go and serve in that department, and you just waited your time. My predecessors just waited the time until they could get back to what they wanted to do in the office. It was not elevated, it was not an experience thing, and if you get most attorneys that come straight out of law school, they've lived their life in an academic world. By statistics, they are either newly married or not married, and most do not have kids. And so what the training I received before I said that's not sufficient from my predecessor was, if you're not sure, go with what the department says. And for a lot of new judges, and I've heard judges in our area tell us that's kind of what they were told. And that removes your safeguards from this process almost completely. Now, fast forward to what we have going on now, I've dedicated more resources. I was the only prosecutor back then. We have grown, but now I've got 3 dedicated prosecutors that all they focus on is child protective services cases. I have 2 legal assistants that focus on those cases. I have elevated that salary to one of the highest in the office for that division. I have made sure they have the resources to function. The homeschool. It's also a mentality to let my folks and my prosecutors know my personal background. My sisters homeschool my niece and nephew, and I have seen that successful. I have hired homeschool graduates that have been extraordinary within my office. My lead prosecutor in that division homeschools his kids. So it's about setting expectations on how to apply that law, but it will be different from my county to another county. And you will see that statistically in some that we were talking about how 22% increase from 2010.
Yeah.
If you look at in removals, if you look at my office between 2010 and in the same time period, we've gone down 16% in removals. Yeah. So that's how do we find a way of leveling the playing field across the state of Texas for application? Yeah. And that's the hard question.
Well, and so the framing document that's in front of you of those 2 graphics shows that every confirmed report, type of abuse and neglect, which, to me, and I want to reiterate, that child abuse is a special type of evil as far as I'm concerned. And so, any child abuse is too much. But the trend statewide, and that's what we have to look at, statewide statistics when we're in Austin, because, for me to figure out what's going on statewide, otherwise I'd have to go to each of these counties and look and see, read those files, which are confidential, I can't look at, to look at what individually is going on in each location. So the statewide statistics just aren't very good, and they're not very granular. And so all we can do is this, which is look at the trend in confirmed abuse, which is down over the last decade. Every form of maltreatment is down over the last decade. At the same time, the removal rate continues to increase. We're adding about 1,500 children to a broken system every year. And so the corollary would be, what if the crime rate, every type of crime in Texas, the crime rate was going down? At the same time, we were building prisons and adding more people in the prison system. That's the corollary. And so if you look at a county like Williamson that's really directing efforts at this, I think that's where success is. And all we can do in the legislature is to make sure that the law is as good as it can be, that forces and gives family defense lawyers like Chris, and gives prosecutors and gives children's attorneys the same playing field. And then it's up to them how they use that or not. I mean, we have some situations and some bad, just bad philosophical models in these counties, because the attorney for the parent tends to be court appointed because we're talking about indigent parents. Well, he's paid by the judge in that court, who gets to look at his bill and decide whether he or she spent too much time or not enough time. It's always too much for the county commissioners. And so you're thinking about that whenever you send your bill in. You're thinking about that when you're in court. It's like every single hearing being like a job interview, because at any point, you can be taken off that list, and you may depend upon that. So it seems like there has been a problem in Houston, around Houston. In 2016, Judge Schmude found that CPS had groundlessly removed a child and ordered the state ordered CPS to pay $27,500 in attorney's fees. And he ordered CPS personnel to read the United States Constitution and the Bill of Rights. In 2015, the same thing. Another judge, Judge Michael Snyder, ordered CPS to pay $32,000 in attorney's fees. So there does seem to be differences. I haven't heard those cases out of Williamson County, which is why we have Mr. Hobbs here. And in that Breitbart article, Representative Burrows said parental rights are one of the most fundamental rights in a society, and those rights must be protected by the state. When a judge determines those rights were not respected, it is entirely appropriate for the court to order those responsible to read the Constitution and the Bill of Rights. And so this was an effort we had and used in this last legislative session, I think, to some effect in talking about protecting parents and in talking about striking this appropriate balance between safety for the children and family, just family autonomy, or the ability to live in this intimate relationship. And so, Representative Burrows, let's talk through some of the successes and maybe then some of the things that we still see on the table for the next session.
Sure. I guess let me start by kind of explaining why a legislator who's on the Ag Committee and Banking Committee is actually up here, because you might have some questions. So before that, I was on County Affairs, and we went to 7 different locations, and we took testimony on CPS. It was clear from Houston Chronicle, from San Antonio newspaper, across the state, everybody was covering this issue. And so we had hours and hours of testimony from the department. We heard horrific stories of abuse that actually happened to children. We had horrific situations we asked our DFPS workers to go into. And I have a lot of respect for the job they do. But at every single hearing, whether it was actually at the hearing or they'd come up to us afterwards, we also heard about a personal hell good parents were put through when they were unnecessarily targeted for exercising their parental rights. The things Judge Schmude articulated well. They wanted to educate their children perhaps differently than their neighbor did. They wanted to bring them up religiously. They maybe declined vaccinations for religious reasons, which is a legal right in Texas to do. That they just had ordinary discipline of their children, but yet because of this, a neighbor or somebody turned them in, their children were removed, or they were at least having some sort of supervision. They were caught in this really difficult thing. It was hard not to be completely blown away at what little rights some of these parents were afforded and wanting to do something about it. So last session, working with Brandon and the Homeschool Coalition, we filed a series of bills. Bunch of amendments. We tried to, number one, we tried to make sure that all of the judges who oversaw this were elected rather than appointed, so they had accountability. That one did not pass. I think we're going to bring that back up. We tried to raise the burden of proof, knowing that the parental rights is this basic, fundamental, constitutional right that everybody has, to make sure that it's a really high standard when the burden goes in. Unsuccessful there, but I think something that the chairman wanted to hear more about and take testimony during the interim. We were successful in asking the Supreme Court to look at the jury charge, so that rather than having this broad form submission, we were actually going to have them list out and answer the different questions on what it is. we articulated very specifically that there was a host of reasons why you couldn't remove children or terminate their rights. One of them we said homeschooling, very particularly, so it's in the statute now. You cannot remove or terminate parental rights just for homeschooling, for declining immunizations, for the legal reasons that you can do so, for ordinary discipline, for low-level nonviolent criminal offenses where literally it'd be much better to have the child still with the parent. One of the things that kind of got put in, and the district attorney and I were talking about it at the end, is there was this kind of catch-all. So the way House Bill 7, which was the big bill that I think we're all very proud of, worked was Representative Gene Wu had a very first draft of it, and he's the bill author and did a great job. He ended up adopting a significant amount of the language from another bill that the Homeschool Coalition, myself, and Brandon were working on for the Policy Foundation into it. And we articulated the reasons why you couldn't remove to make sure everyone in all 254 counties knew you couldn't do this. But he put a catch-all provision at the end, and it was the way we got it in there, that said, well, you know, this doesn't mean that it's necessarily this information is excluded from the court. And so there's a back and forth in legislative intent, and I said, well, is it really relevant? If it's legal that somebody is homeschooling their child, why should that even be brought in? Because there are biases out there against it. You know, my background, my wife was homeschooled. We often talk about doing the same thing. She's a wonderful individual and was reared by great parents. And so I'm a very big proponent of making sure people have those rights. But not everybody agrees with that. And so why are we going to have that information even being brought in front of a potential jury if it's not relevant, it's legal? And I think we're going to have to come back and take a look at relevancy standards and what the statute actually says next session to make sure that we clearly define what actually needs to be in front of the court. So those were a couple of things. We also talked about making sure that allegations against both parents are articulated, not against just one. It was a really interesting thing because one parent's rights can be terminated even if they did nothing wrong just because the other parent was abusive. We wanted the department to actually articulate standards on both. We got that on an amendment. The department came back and said, well, that's going to cost us $38 million a year at the end of session, which fiscal notes are an interesting, different issue. But, you know, that ended up killing the amendment, and so we're going to have to come back next session, I think, and address that.
Yes, and so many of our families, I mean, and I'm sure you can imagine, a lot of our children are removed from single parents. And so the issue has been with what Representative Burrows just discussed was, when you remove a child from one parent who has done something wrong, what about the other parent? You know, all these kids have two parents, and it's better, cheaper, more efficient, better for the kids to look at this other parent. And so Chris and Judge Schmude and I are on a group that really came out of Representative Burrows' amendment that didn't make it because of the fiscal note to really look at that. And Chris, I mean, can you talk about sort of some of just the agency philosophy that we're encountering in that group about what we call non-offending parents? These are parents who have not abused their children, not neglected their children.
Yeah, and that's the key there. Even the people that disagree with us have the term non-offending parent. And the basic question is, why did you file a termination suit trying to take the parental rights away from the non-offending parent? It seems like a fairly rational question that the folks on the other side don't seem to get. And we've been to 2 meetings now over this issue, trying to work on the pleading practices of CPS. And their basic philosophy, their idea is that, well, the child is brought into state custody, and we have certain responsibilities, and you as the non-offending parent have to prove to us that you are fit in order to get your child back. Well, excuse me, no, we have this thing called the Constitution where you, the state, have to prove that I'm unfit. And that you could just see the blank stares. Actually, it turned into horror when one of them finally, I think she was reacting to you, shot back at something you said and said, it sounds like you just want us to turn the child over to the parent without knowing anything about them other than we don't know that they did anything bad. And you said, well, yeah. And the look of horror and shock on that side of the table's faces just said it all to
Well,
me.
and so amazingly, this is the minimum they want. The minimum that the agency wants is if they remove from a mom, or let's say the boyfriend did something bad and we all agree was bad, and even the mom should have known what was going on or knew or should have done something about it, right? Well, you've got dad over here, and you've talked about a trucker who was on the road.
That's
and
true.
didn't know.
I guess we should tell folks what the concept is.
Right.
In divorce situations where mom and dad are not living together, or even in situations where I had one case where the dad was a long-haul trucker, and he was home 3-4 days a month. And mom had done a very good job of hiding a cocaine addiction from him. And she was busted while he was out on the road somewhere. And the whole reason he wasn't getting his kid back was because you should have known your wife had this problem.
And
well,
so then
that's
then
not much of a legal standard.
And so then the agent, what the agency wants to do at a minimum is before they return the child or give the child to the non-offending parent, they want a home study of that home, and they want to have that parent go through some psychological testing and prove, that they're fit. And so really that shifts the burden from the state, who has the burden, should have the burden because it's a constitutional right, to the parent to prove that they're not abusive or neglectful. And it's impossible to prove a negative, right? And so that's sort of what we're asking to do. And in every one of these cases, and I asked the agency last time we had a meeting, in what number of cases do you only file a petition to terminate the rights of a parent against one parent and not the non-offending parent? And they said they didn't. In every case, they file a petition to terminate the parental rights against both the offending parent and the non-offending parent. And again, I'm not saying that there are a huge number of these, and Mr. Hobbs, you might be able to sort of talk about whether this is a problem, how your office deals with it, and how it works out in practice.
Well, I can tell you one of our biggest problems, and it's similar to your long-haul trucker, but in a lot of our instances, we have an offending parent and we can't locate the other parent.
Right.
Something happened between the two, the other is just in another state often. And we had a case where we could not find them and we had to move forward in protecting the children. But guess who we were able to find right before we went into a hearing, and we were able to place the children with that parent. But there are hurdles. There are things that everyone wants to be belt and suspenders both, and it's where the judiciary comes in that helps a lot with exactly what y'all said. Parent came forward, no need for this. You haven't shown any reason why other than they've been absent and placed with that parent. That's what we see a lot, is where we just can't locate the other parent, or we have allegations against both.
Right.
We have evidence of they knew what was going on, not you should have known, which you're right is.
Yeah. Did know and should have known are two very different
Yes.
things.
Right. So one of the things that Representative Burrows was successful in helping us get into House Bill 7 was sort of discovery or some information that must be provided to the parents prior to the hearings where we temporarily take away their rights to their possession. And so now, Representative Burrows, can you comment on, now it seems like there's at least something that must be proven to the other side so that at least parents can know what the allegations are.
Yeah, I went to law school. I've never practiced in this area, but I have some basic understanding of, criminal law and family law from my studies. And I know that if, this was a civil case, which is where I practice, and someone was taking away my property, I'd be entitled to discovery, afforded a lot of due process, and I have a lot of protections. If I was on trial for criminal, I'd have a lot of, discovery opportunities and a lot of due process, a lot of protections. I was astounded over the last year to learn that some of those same basic notions of due process in some counties were not afforded to the individuals, and we didn't value parental rights the same as we did life, liberty, and property. And so this just seemed like a natural thing that should have been being done already, and it surprised me that it wasn't. But as you continue to go across the state and you realize that it's just amazing how, I think it goes back to the basic discussion. In my philosophy, the parental rights predate even the Constitution, but they're definitely protected by there. There's just a natural, fundamental parental right that exists. I think a lot of people, especially in politics, expect that already to be there, but they don't ever see it on the CPS side. What you learn is On the other side, sometimes on the agency side, they almost think it's the state's child. And you start with everything against you, and you've got to prove that you're a fit parent. And that doesn't make a lot of sense from just a basic philosophical legal standard. And I know there's some good counties out there, so I don't want to disparage that this is the same way across the board. But getting little things like that into the law will hopefully bring the bad actors that we heard about into conformity with the good actors and do things they should have been doing already by giving you at least an opportunity to defend yourself and protect that basic fundamental parental right.
You want to go?
I can just tell you three things as the presiding judge of a family court that has a very busy CPS docket that I've seen that is frustrating when it comes especially to non-offending parents. The first is, and Chris, you touched on it, it's this burden shifting. This notion that the burden of proof is on you to prove to us that you're a fit parent. That has it completely upside down. Troxel versus Granville is a very important U.S. Supreme Court decision. I think it came out of Washington, if I'm not mistaken. Right. It held that parents are presumed, fit parents are presumed to act in the best interest of their children. So parents, by virtue of being parents and holding those fundamental constitutional rights, you have the benefit of that presumption. That means the burden of proof is on the state to rebut that presumption, to prove you're not a fit parent, that you're not acting in the best interest of your child, and your child is in some kind of danger. So that's the first thing, is a burden shifting. Secondly, there's this common perception, and it's kind of frustrating, that the best interest standard applies to removals. We see the best interest standard applied throughout family law cases, and in custody cases, your standard custody cases, the standard is what is in the best interest of the child. Well, when it comes to removing a child from parents or burdening a fundamental constitutional right, that isn't the standard. That's interwoven into it, but the standard is a lot higher. Again, it's strict scrutiny. You have to rebut the constitutional presumption, and you have to show that the state's compelling interest outweighs the individual's constitutional rights. Okay, so the standard of proof is not just a simple, well, it's a non-offending parent. Maybe he didn't visit last month, or didn't exercise all his visitations last month. I think it's in the best interest of the child that the state have possession. No, that's not the standard. It isn't best interest. You have to show a whole lot more than best interest. There was a third thing. I'm having a Rick Perry moment right now.
I'll let you think about that, because none of us want our parenting judged by what's best for our child. Because it's probably best for my child that he be taken from me and put in some very wealthy person's home that's going to allow him or her, all of the opportunities that I simply won't be able to give him or her. He can go to Harvard and become president of the United States. And while I know that's an option for my child, the likelihood, from West Texas is less, right? So we just start asking what's best. Is it best for your kid that they stay with you, or is it best that they go somewhere else? We don't want to start that debate, right? So we need this bright line rule of exactly, and that bright line rule has to be immediate danger, not what's best.
I remember the third thing I wanted to mention was, and I see this repeatedly, we have these directed towards non-offending parents. There's really no evidence that there's been any abuse or neglect, so you see these kitchen sink pleadings. That means you get a pleading in every single ground for termination that's set forth in Section 161 of the Texas Family Code is put in the pleading. And so you got these parents, these non-offending parents come in here and they're like, I've been accused of this and that and murder, abuse, neglect, all these things, and they're extremely upset. First of all, I think it's counterproductive to, if the goal is permanency, having those kinds of pleadings is, first of all, from a practical standpoint, is counterproductive. Secondly, from a constitutional standpoint, it violates procedural due process. It would be like walking into a criminal court and you meet the prosecutor, and the prosecutor says, "Good morning, the indictment is the entire Texas Penal Code." So there's your notice. The respondent has to be put on reasonable notice of what the moving party is seeking and the grounds they're seeking termination on. And you need to have a good faith basis for pleading those grounds. And that's supported by Rule 13 of the Texas Rules of Civil Procedure, as well as Rule 10 of the Texas Civil Practices and Remedies Code.
We're really earning our CLEs with all of these cases and rules we're throwing out. Mr. Hobbs, did you have something to add?
It was just about that great legislation about making sure the evidence is provided ahead of time. It frees up. You got to understand there's also someone looking over my shoulder on, are we using funds properly? Anytime it helps when the state gives an edict. We want to do it, we do it, but I still have to justify it locally. So that's helpful. Now, the sad part, since September, when that went effective,
Right.
do you know how many times that evidence has been requested? How many times all the evidence being requested,
It's available.
it's available, how many times it's been requested before that hearing? So we did better than you thought, but once. And I don't have the numbers to date, but a lot.
Yeah.
A lot more than one. And that's a sad part. I'm hoping that it will catch on as more do-it trainings go out there, but we also have a good relationship with our defense bar. But I worry because we still have problems in ours, and a lot of it is the bureaucracy of a state agency on what they want to see happen before we're safe.
Yeah.
So we battle the same things. Please don't say this is a utopia that I've got going on here. We battle and we kick and we scream and we all do that. We have a lot of good caseworkers that we work with. When we have a problem, that's another thing that we battle with, is getting some change made. And that's one reason why at the legislature it was interesting about trying to look at ways of giving local control over the department to have more of an immediate response. We have a lot of great caseworkers, but a few bad is too many.
Yep.
And it also mirrors the work product of the good ones. And
right.
so I like to see that direction of the legislation.
Well, unless there's some closing remarks up here, it's time for questions, and we welcome those. We hope you have some questions, not just to test us, but also because there's things we haven't covered, and I'm sure there are questions in your mind out there. Christy?
You know, so we had a lot of bills that went through the legislature and worked with DFPS, and you know, we're not talking about the norm. I mean, these are the exceptions, in my opinion,
Right.
a lot of times. There are a lot of times where we're doing removals and termination. Y'all see it firsthand, where clearly there needs to be just that. It's an interesting thing, right? So we're sitting out there and we're having all of these stories written and legislators bearing down on that agency. And for good reason. They've messed up in a lot of times. But what happens? Well, now they get nervous. And sometimes they think the easier thing to do is to do a removal rather than not, for fear that they're not going to get, they're going to get criticized later on for not doing it, given what some of the stories are. And so and we continue to try to have changes in there. Change was needed, but if you look at it, there's a huge report that comes out every 2 years, and we've tried to make sweeping changes every 4 to 6 years, and we continue to try to do that, and there hasn't been continuation. I think we have the right person at the agency head. They're making really good decisions. If you talk to him, you'll realize that he's got the right angle, and I have confidence the agency is moving in the right direction at this point in time, and the governor's appointed a really good man.
Yeah, and so it used to be that DFPS was buried in the Health and Human Services Department, and so there was probably less line of sight for the governor, and one of the changes that were made in these reforms were DFPS, the Department of Family and Protective Services, which CPS is a sort of an entity of, was put in as its own agency with direct responsibility and accountability to the governor.
And if I just wondered, but a lot of this is at the foot of the judges. To defend your department, I don't do this often, so listen up. I see that judges have certain wants and likes, And I see judges that get irritated when a CPS attorney actually tries to give due process to the parent. And over time, they just give up. They fall in line with what the judge wants. And if the judge doesn't care that much about due process, no one else is either.
Christy, back here.
So many of these horror stories start out with like an overzealous, nosy neighbor who, you know, calls the authorities. So it seems to me that, you know, while the legal aspect is obviously very important, there's a societal change that we went through that people, you know, neighbors or society in general wants the authorities to get involved. So how did that arise, and what can we do to combat that as well?
I can take that and y'all can chime in. So Texas is one of a few states that has a mandatory, every citizen is a mandatory reporter. And so every citizen has a duty to report child abuse and neglect. We also have anonymous reporting here, and so you can call in and you can make your report anonymously. There is a criminal penalty against making a false report, but if you can make an anonymous report, it's unenforceable to have criminal penalties against false reports. And so some of these reports come out of, you know, just family scuffs, neighbor disputes that don't have anything to do with children, but weaponizing CPS against one another, either in the family or in a neighborhood situation or in a group of friends. And they, you know, so that's a problem for sure. And really, there is a cultural change, I think, where, you know, parenting, you know, this helicoptering parenting is a real thing. You know, the things that I did as a child on my bike from 5 o'clock until, you know, the street lights came on. You know, we don't see children do that anymore. And there are several efforts throughout the United States. And recently, I think last week, a group of Harvard professors say, please let your children play unsupervised, because when they come up here, they are not prepared for this really unsupervised life in a college setting. So, Christy, there's a question right up here at the front.
Wait a minute. In regards to that, though, I do want you to know, and I'll mirror what the representative said, a lot of this is being done right on a daily basis. I'm here today because I don't want there to be the wrong at all.
Yes.
One is too many, and we have more than that.
Right.
With the reporting system, you got to remember, the system is doing what it's supposed to. When something gets through, the system has failed. Because out of 4,000 calls that get reported, you know, 2,000 of them will actually be assigned. Half of them are weeded out immediately. Another large portion of that is weeded out before investigation begins. So there's a system, a filter in place. What I look at where a lot of failures happen is not necessarily with the system, it's application of that system when we get something through. So,
and I want to point out again that this is a problem, but the majority of cases, kids need help. They need to be removed. Parents need to be rehabilitated. And so I am not here to tell you that we need to cut this loose and turn parents loose. What I am here to tell you is that case I told you at the beginning, where that child was removed from that single father who was just overwrought, who ended up being sex trafficked in Houston from a small West Texas town. That's the case that haunts me out of all my cases. It's not the cases where a kid was removed and ended up even in a bad situation in foster care because he needed to be removed. And what happened in foster care was bad, but it wasn't as bad as what was going on at home. The cases that haunt me today are cases where kids would have been better off left at home. And a federal court judge recently said we have a lot of kids in our CPS system that would have been better off left at home. Question here?
I just wanted to add that part of the problem, I believe, with the change in society is the fact that we have so many people that are like pet parents instead of child parents. I don't think they understand what it is all about, and I think that's where a lot of that comes from. The other thing I wanted to say is that I'm very concerned about the judges, especially, I happen to know the politics in the last 9 years. I'm part of the community team, and it seems to me that legislation and politics is all about personal experiences. So if you have a judge up there who was abused as a child and nothing was done, I can see them wanting to err on the side of removing a child. But one of the other problems I have are the judges that don't even know the law. You know, we elect our judges in Texas, but we've got to do something better about having some requirements. You know, I have a problem with civil lawyers that want to become family court judges and vice versa. We need to do a little bit better about making sure our judges are qualified before they run.
Do you have anything to?
Yeah, I would absolutely agree with that. Yeah, being involved in the political process is so important. I mean, judges are directly elected. If you don't hold judges accountable, if you don't ask those questions really that kind of get to the meat of the issues, you're never going to know. You're never going to know who you're being, who's rising to the level of the bench and making extremely important decisions about the safety and well-being of children. So important. I mean, you mentioned, Brandon, I love that word, gatekeeper. A judge is a gatekeeper. We're not there to be a rubber stamp. We're there to take an objective view, apply the Constitution. We swore an oath to uphold, to preserve and protect and defend the Constitution and the laws of this state. And that means something. That means you have an affirmative duty and a very important role to play in the whole process, making sure we elect judges who know the law, who know what they're doing, who have a background in CPS cases before managing an... Absolutely. Right. I couldn't agree more.
I would just add, I think the vetting comes at the constituent level. I mean, that's where it ought to be. And we don't ask sometimes the best questions. We don't know everything what to ask, but I've watched candidate forums for years. I've been involved in local Republican politics, and judge races are difficult because we don't always have the right questions to ask. But I just think that a better vetting of constituents and potential voters and asking questions and getting the philosophy and trying to draw it out. Too often I hear sometimes judges say, well, I can't comment on that because, you know, I might have to hear it, or some of those types of issues. If that's not acceptable to you, don't let it be. But I would continue to just ask questions, because sometimes the most experienced judge may not have the demeanor and personality that's best suited to be on the bench. You know, the best person ought to be in there, and that's up to the voters to make sure they determine who that is.
And I think they need to split some counties.
Yeah.
We have, what, like 70 judges on the ballot.
And I would put a plug in for the Texas Homeschool Coalition. They're getting more into the parental rights arena, and they have started, I was honored to be on a judicial vetting board, and they are putting out endorsements and such. And
Mr.
yeah.
Hobbs, you had a...
We've been doom and gloom. I want to bring some
Yeah, no. absolutely.
sunshine to it to illustrate exactly what you said. I agree with you 100%. We are very fortunate in Williamson County. Our presiding judge, Judge Betsy Lambeth of the 425th, ran heavily on her involvement of representing children, but also majority of her representation was representing parents. And so when she took the bench, she had that perspective. She and I went to battle in hearing after hearing from those two sides, and she has taken any new judges that come on that are asked to handle that caseload under her wing. But that's not something she's mandated to do. That's not something she has to do. That's something she chooses to do. But she also didn't wait for someone to ask her the question. She jumped out there to tell the constituents what she would be able to do. And that's kind of what I would love for our locals to look for, is someone who brings that forward and doesn't wait for to be asked. So.
And one of the bills that Representative Burrows had was to address this problem of having elected gatekeepers, both Mr. Hobbs, who's an elected gatekeeper for his local constituents. Whenever CPS brings a removal to him, he can say, you're going to have to go back and do better than this. And so he's a local gatekeeper for his elected constituents. And then an elected judge who's a local gatekeeper whenever the case gets into court. And we have in the state, we have certain counties in which CPS represents itself and decides whether it should file a petition, because its attorney is a hired attorney with CPS paycheck. And so there's no gatekeeper for that. And so those cases get into court. And then in many of those same courts, we have an unelected judge that's hearing those cases. It's called an associate court, and the judge is hired by an administrative regional judge who is not elected. And so we have this series of checks and balances that don't happen in those certain cases, and that's why we'll hopefully be back to address that same issue. Making sure we have these checks along the way so that we are keeping CPS, holding them to their burden. And I want them, if there's any of these cases we've talked about, and like I said, if there's any of these cases, I just want CPS to do a better job, and they can. They can investigate harder, and they can do a better job so that you're happy whenever they bring the file to you, and so that you're happy whenever the case is presented to you. There's a question over here.
I'm glad you brought up the unelected part, because out where I'm from, we have an associate judge who's appointed, and we have the CPS prosecutor come out from San Antonio, and, you know, sometimes it's not the same person 2 days in a row.
Yeah.
You know? And so you don't have any checks. And it's obvious, I defended the kids and the parents for about 10 years before I finally said, this is ridiculous. You know, I'm just wasting my time. It's obvious that the CPS judge knows that as long as they get along with CPS, they'll get reappointed. And so there is no opportunity for the attorney representing the kids or the parent to make the constitutional arguments. You know, the best you can do is get run over in the initial hearing, or which is always too soon, and try to appeal it to a district judge. Well, the district judges out there have no training in CPS. It's going to be 6 weeks before you can get a hearing, given the nature of the dockets out there. So fundamentally, there is no adversarial relationship which the system is designed to create. The second thing are the anonymous tips, the anonymous accusations. I'm involved right now in a divorce, a custody situation, where somebody made an anonymous situation claiming that the stepfather was abusing the 2 children of his wife. Boom. You know, we got him out of there before CPS took the kids, but we'll never know who did that.
Yeah.
And shouldn't that be part of the evidence that we get? I haven't studied HB 7, I dropped out a couple years ago. Shouldn't that be part of the evidence that we get? In a criminal case, you know who your accuser is. In a CPS case, they can have a string of anonymous tips as long as you're armed, and you never know who any of them came from or what the background is, but they show up in every CPS petition and in every CASA report as if they were true. So how do you ever get to the opportunity where the court actually has the opportunity to evaluate the legitimacy of the fundamental complaint that results in putting these kids potentially at jeopardy?
Chris, right to confront your accuser?
Yeah, if I could point to one thing that would cut down on the excesses of CPS, and I did want to play off of something you said earlier, sorry, that I'm not here advocating that we slay the beast of CPS.
Right, no.
I hate your agency from time to time, but it's because of the excesses that happen. I'm working to make the agency better, not to eliminate it. It is a necessary agency doing a necessary function. I just want it to do it well and with the confines of the law. But if I had to point to one thing that could cut down on the unnecessary intrusion, it would be the anonymous reporting, because I've had caseworkers admit that she spends half her time running down stupid allegations that she knows was made by a mad neighbor or something like that. So I would meet my opponents on this issue halfway. Confidential reporting, but you got to put your name on it. Yep. I think that would drop the number of calls as much as the Dow lately.
Yep. Much as the Dow.
I think it would really cut down on everybody's workload.
I think we have time for one. Oh, yeah. I think we can get to. Okay.
I missed part of the presentation.
Sure.
I'm sorry I did. I was a divorced mother for many, many years. Did my best, and I think I did a pretty damn good job. They were my focus.
Yeah.
My children were my focus. I would leave Broncos a lot of time to have a single mother 2 blocks away. I called CPS. These kids are neglected, horribly neglected. I brought groceries, several there, okay, the whole ugly mess. 3 children, 3 different dads. She's got all the time.
Yeah.
CPS worker on my block said, you need to call CPS because you know what happened. You need 2 of us. So we did. I think she made a she definitely need to run.
Yeah.
Nothing has happened. Bottom line is nothing has happened. She's been in trouble before. I don't ever drive out of the house where I don't feel pain.
Yeah.
For those kids, and I don't, and nothing's gonna happen there. Nothing's gonna happen. They'll stay there. They'll be screwed up. And I know I'm not angry, but I am.
Yeah. Well, there's.
And it's hard
I'm
for me,
angry
and
too.
I don't know what you have to do to get kids out of them. There's no father involved.
Well, what we've talked about up here
So I
is.
just got to vent because
That's okay. I'd love to vent with you sometime. We could just get together and drink a beer and vent all we can. But what happens is, because we've heard all of these different perspectives. It depends what court you're in, what county you're in, who your prosecutor is. The results in the system are arbitrary and capricious. There is a place.
I made it confidential.
Yeah.
My name.
Yeah. You have right.
And the CPS workers apologized. Oh my God. I said, you know.
Yeah, so there's a lot of arbitrariness here, because it depends on, and so that's why we're working at the law. At least I want everyone to know what the rules are and have the rules be the same. But then, I talked to some people and CPS is too intrusive. I talked to other people and they're not intrusive enough. We had one last question back here I want to make sure we get to.
Thank you. I'm Marvin Gill. My reason for speaking to you guys now is just that I'm aware of certain guidelines where one of the main ones is best interest of the child, but then there's this reunification focus that we have and permanency. Yet, when you have a broken home where there's just two separate parents, there isn't anything that allows the other parent to come back into their home, or have that child rather, not just come back into the home, but to have that home with that other child.
Yeah.
So is there anything currently that's working towards that? Because other than that, I haven't found anything.
Yep.
So I was just curious. And I've looked, and to be fair with you guys, when I looked at these guidelines, when I looked at the statistics from children that were taken from DFPS, and it's actually very hard for them to take a child unless there is some real real source showing that there is some neglect or some abuse. Other than that, it's very difficult to take the child or remove the child, excuse me. But other than that, about 4 years ago is when I looked at the statistics.
Yeah.
There isn't really any reunification yet that's under the guidelines.
Yeah, so we're completely out of time, but whenever we talked about the non-offending parent and the efforts that are happening for this non-offending parent, no abuse and neglect allegations, and why are we filing a petition to terminate their rights? Why are we not reunifying immediately with them? That's really what you're talking about. And so I'm sure Chris would talk about our work on this non-offending parent and people who truly are innocent. These are innocent parents because they've done nothing wrong.
Can I say something real quick?
Yeah, oh, sure.
Just something real quick on that. I think it's so important that the service plan be tailored to the unique circumstances of the case. Yeah. If our goal is reunification, if you have a service plan, like if a child is removed because of neglect, for example, but the service plan requires drug and alcohol assessments and counseling and therapy, when there's no history of mental abuse or no history of drug and alcohol addiction, it becomes counterproductive. And I've seen these service plans, they almost seem like they've been cut and pasted from another service plan. Yeah. So it's important to avoid boilerplate service plans and make sure that the service plan is narrowly tailored to the unique circumstances of every case, and I think that would foster that goal of reunification better.
All right, so we're over time, so I want to make sure we thank our panelists who are here on their own accord. I'm sure me and some of the other panelists are happy to wait around for questions if we didn't get to your question. We are 3 minutes over. If you want your time refunded, you can go to the registration